Yes, sir.
We love Wednesdays. What do we love about Wednesday? What? You can't say that. Today is going to be especially exciting because we're going to talk about requests for admissions. How can you spend an entire class period on requests for admissions, you ask? Isn't this easy? Aren't you just asking the other side to admit stuff? Kind of. But this is, in many ways, as we'll see, can be more of a landmine to step on in litigation than interrogatories and requests for production of documents. But first, what's happening in your legal universe? Agent of the federal government. All right. Well, listen, if you really like this kind of stuff, then might I suggest an employment practice. This is the kind of stuff that you, well, I don't know, actually. I've had a lot of bad stuff, but I never had a guy with an SS tattoo that was the supervisor of an employee that was a person of health. I mean, as you can probably imagine, this case has already survived summary judgment. But, you know, what's weird from an HR perspective is that they haven't fired this guy. But the procedural aspect, I suppose, that's interesting in this, I'm just showing it to you because it's horrible and weird, and this is what employment discrimination practice can be like sometimes. But the procedural aspect of the thing that's interesting is that you can't just go, even when you're, because the defendant in this case is the federal government, but even when your defendant is not the federal government, even when the employer, even when the wrongdoer is a private actor, under certain statutes, Title VII is one of them. When I say Title VII, those of you who take employment discrimination or any of the labor law classes will touch on that. That's the employment discrimination federal statute, right? Kentucky has an analog and most states have an analog. But if you want to go the federal route and you want to sue your employer in federal court under Title VII or under the Americans with Disabilities Act, you've got to first go through what's called the EEOC, right? The Equal Employment Opportunity Commission. And you have to do a thing with the EEOC that is basically what we call exhaustion of administrative remedies, okay? It's not like a torts case. It's not like a battery case. It's not like negligence. It's not like even a contract case. You can't just run out and file your employment discrimination suit in the federal court. You have to go all the way through this agency's process, their administrative process, and then they give you a letter called a right to sue letter that says, okay, you've been all the way through our process now. We've done our investigation, and 98% of the time it's like, yeah, we didn't find anything, so, but go ahead and sue if you want to. And then you can sue within 90 days. That's exhaustion of remedy, okay? That's about the only thing procedurally interesting about that one that we can talk about. Although I'm sure it's an interesting case. Questions about any of that? Let's talk about RFAs, requests for admissions. What can you ask someone to admit? You read the rule, of course. This itty-bitty reading that you had, surely everybody did that itty-bitty reading that we had. What can you ask for? This isn't that hard. I mean, but give me a chapter and a verse that says what you can ask for. Where would you look? Yeah.
Rule 36,
just says that you can ask for stuff, right? What is it that you can ask for? You can ask for facts. You can ask the other about the genuineness of any described documents. So in other words, you're asking the other side, admit that this document is what I say it is. Okay. That's simple enough. But 26B is still our conscience here, right? 26B is where you go back to the extent that 26B helps. 26B defines the scope of discovery. Right? And you'll be less concerned about, I think, you'll be less concerned about what can I ask the other side than you are about, is it proper for the other side to have asked me this question? Does that make sense? And so for that, you go to 26. And if somebody has tendered you a request for admissions that is not relevant to the action or asks for privileged information, right? Those are the two big categories. You can object. But your scope of discovery is still defined by 26B. That's something important for you to know, not just about requests for admissions, but also all the other stuff we've been talking about the last couple of classes, right? RPODs and interrogatories. What are the ways that you can respond to these? You can admit, sure, admit. Come on. Think about if you really want to do that. But in some cases, it's appropriate. Why not? Don't be afraid of that. Deny? Sure. Admit some things, but deny the other things that are contained in one question. Is that okay? Can you admit in part and deny in part? I see lots of heads bobbing. Yes, of course, right? Specifically contemplated by the rule. But can you say, we don't know? I can't admit or deny that because I don't know. Can you say that? What? That way, but in what way? In what way? How do you do that? How do you go about saying,
at present
we don't know? What?
At present we don't have any permission to verify.
Might the rule tell you a little something about that? Maybe. All right there, paragraph 4, right? If it's not admitted, you must specifically deny or state in detail why the answering party cannot truthfully admit or deny it. Okay? And then get down here. This is the magical stuff. The answering party may assert lack of knowledge or information as a reason for failing to admit or deny only if the party states that it has made reasonable inquiry and that the information it knows or can readily obtain is insufficient to enable it to admit or deny. What does that mean?
You have to have made an effort to find out in good faith. Or well, a reasonable effort in what you know or can get to is not enough to let you admit it's not.
You got to say, that's right. You got to say, we tried, or we're trying, but we don't know yet, and here's why. Okay? Back to that language in a second. But those are the basic ways that you can respond to these things, right? Admit, deny, admit in part, deny in part, and then say, I don't know, but track that rule because there's a very specific way that you have to say, I don't know. Okay? When you're answering this kind of discovery, might it be a good idea to have the rule in front of you? Especially when you're doing that kind of I don't know sort of dance that you have to do sometimes. You need to track the language of those rules. For all this stuff, not just for requests for admissions, although it's particularly important with requests for admissions. Why? Think about what we talked about with interrogatories and requests to produce. The rules say respond within a certain amount of time. We're talking about interrogatories. The rules say respond within how many days?
30.
30 days. What happens if you don't respond within 30 days? To interrogatories. Talked about this. What happens if you don't respond within 30 days to interrogatories?
Yeah.
Probably get a nasty letter, after which, as we'll cover on Friday, maybe somebody moves to compel. Yeah, that's what you're going to say? Maybe you get an order from the court somewhere months later, right? These discovery disputes will play themselves out. What happens if you don't respond within 30 days to a request for admission? What does the rule say happens? This is the important distinction between all the other kinds of discovery that we talked about and this. Yeah.
You admit to the request.
It's deemed admitted. It's deemed admitted. Why might that be a problem?
Maybe you didn't actually do it.
If you get a request for admission that says, admit that you are the Boston Strangler. That's a bad example. Admit that you are the Zodiac Killer. They never caught him. And you just let that go for 30 days, and on day 32, it's like, oh yeah, I was supposed to answer that request for admission about whether or not I'm the Zodiac Killer. Guess what? You're the Zodiac Killer. Right? So as you see in the Azia case, right, that can have a pretty bad effect because chances are, how many requests for admissions are you allowed to tender? What does the rule say you're limited to? How many? How many do you get to serve? Let's say that we're in the Western District of Kentucky. How many requests for admissions do you get to serve on the other party? What's that?
There's no limit.
There's no limit. There's no limit in the federal rules. Right? Where else might you look for limitations? Oh, okay. Local rules. And then how do we do that? Hold on. Well, we'll look it up in America's search engine, which, of course, is being local rules for the Western District of Kentucky. And how do we know right away? We said it. No one remembers. It's lonely up here and no one listens to me. But we're talking about Rule 36, right? Rule 36 governs requests for admissions. Do the local rules say anything about Rule 36? No, because these local rules correspond to the federal rules. Now, what about you? You can do this on your own. The Southern District of Indiana. How many requests for admissions can you serve in the Southern District of Indiana? Who knows? Many of you have computers in front of you, so you can probably figure it out very quickly. 25. 25 per the local rule. See how much fun this is? That's only 5 minutes away from here. File a case here, you get unlimited requests for admissions. File a case over there, you only get 25 without leave of court. Right? Look at some examples. Give a detailed answer, right? Oh, well, let me go back to my original point, though. Somewhere in your opponents, especially if you're over in Kentucky and there's no limitation at all, somewhere in your opponent's gigantic set of requests for admissions will be everything that they need to make the case against you, right? No matter what side you're on. You can't let these go beyond 30 days. What if you need more than 30 days to answer the stack of 7,000 requests for admissions that you've gotten from the other side? What do you do? Let's go back to interrogatories. What do you do if you need more time to answer interrogatories? What? Ask. Ask who? The other side, right? The other side says no, then maybe you go to the court. What if you need to ask for more time on requests for admissions? What? What's a safer route? Ask the court. Yeah. Ask the court. You can ask opposing counsel, and you should ask opposing counsel first, and then submit an agreed order that says, I get more time to do this, right? That's much nicer. And in some places it's required. But that's much nicer than just wasting the court's time with a motion that says, I really need 35 days on these requests for admissions, not 30. But if you don't answer them within 30 days, by plain operation of the rule, you've admitted that stuff. So this is a landmine that you would not think would be easy to step on. But you can. Give a detailed answer, track the language of the rule, right? Especially if you're denying. You're saying, I don't know. Can you object to these? Sure you can. What governs the scope of your objections? How do you know what objections you can put? What's the rule? What? I heard it. Still Rule 26. All right. 26P gives you what you need. You don't like the answer that the other side has given you to a request for admission, then what? How do you handle it? What's the rule? Chapter and verse.
Requesting party may move to determine the sufficiency of an answer or objection.
Where do you get that?
36. Yeah, A6.
Motion regarding the sufficiency of an answer or objection. It's like it lays it out for you, right? Make a motion with the court, determine the sufficiency of an answer or objection. Unless the court finds an objection justified, it must order that an answer be served. Okay? It tells you procedurally how to handle it. Go through the rule. Make a motion regarding the sufficiency of the answer. And say, Judge, I don't like the way the other party answered this. That's an improper objection. It's not answered within the meaning of Rule 36, and I want a different answer. What happens if the court looks at your answer says, I don't like that answer, you haven't sufficiently answered this, and as we saw in our case reading, just deems the matter admitted. I think, plaintiff, that you're hedging a little bit too much on this one. You haven't answered within the meaning of the rule, and therefore, I'm going to deem this request for admission admitted, and you are, in fact, the Zodiac Killer. What do you do? What do you do if that happens to you?
Move to withdraw or amend.
Where do you get that?
Pull it out of my,
Is that right? Yeah, you just know that off the top of your head.
Rule, these numbers and letters are confusing. I think it's 6B? No.
36B tells you. Right? Make a motion to do what? What's your motion? How are you going to style your motion to the court?
Motion to withdraw.
Motion to withdraw or amend admission, right? Or admissions. It's all right there. Pretty simple, right? You got this? No problem. Easy. How many can you serve here? All right. So you will oftentimes get the question that just says, did you violate the contract? Did you commit the tort? Are you liable? Right? That sort of thing. That's not uncommon not because the other side is expecting you to admit to liability, but because the other side is expecting to catch you up, or hoping, anyway, to catch you up in a time limit sort of thing. You don't answer your request for admissions within 30 days. Or they want to use some other procedural device to get that request for admission deemed admitted and catch you up in that. But far more common is a whole bunch of requests for admissions that break down the action into little pieces. Right? So if you're serving these on the other party, think about, it's not really enough to send over a set of requests for admissions that just says, did you commit the tort? Break down the tort to each one of its elements. Right? Break down the action as small as you can. Get them to admit to little pieces that hopefully, along the way, will add up to liability, or at least get you close. So consider using these to figure out what you agree with the other side on, so you don't have to try those issues. A lot of times you don't know when you get into a case, when you first start litigating a case, you don't know how hard the other side is going to fight you about every little thing. Were you present at Wick's Pub on the evening of June the 9th, 2019? Admit. Okay, Now we're getting someplace. We don't have to fight over the identity of the person that was at Wick's Pub June the 9th, 2019. So to the extent you can whittle down what you have to prove to make your claims or defenses, you can do that pretty effectively with these requests for admissions. Right? This is fun, right? Here's an example. An actual set of these. This was the entire set of requests for admissions that I got in a case long, long ago in a contract case. Although the name of the corporation is not really Evil Court Builders. But that's it. Admit that there was no contract. Deny. Simple as that. Move on. Right?
So you had different detailed information.
Something like that. Something like that. That's a simple, straightforward question. Doesn't require any further expounding. Did you enter into a contract? No. Other example requests. We already talked about the first one, but think about the second one and the third one together. And think about whittling down the annoying things that you might have to litigate over throughout the course of the case. Right? You get these out on request for admission, that's some time that you don't have to waste in a deposition. And if the other side denies this stuff, just to deny it, just to be a jerk, then that gives you a basis to go back and smack them over the head with those denials after you prove that they lied about this stuff in their request for admission responses via a deposition or some other discovery device, right? The way this works is, admit that your signature appears on the document labeled as Exhibit C, deny, and you get that witness under the hot lights in the deposition. Say, hey, is this your signature? Yeah. Okay. And you go back to the court and say, hey, we had to spend this extra time in this deposition trying to figure out if this is this guy's signature or not. And so I want my attorney's fees for having to do that. The court may give them to you. Right? So don't play games with requests for admission if you're responding or if you're asking. What's the point of these last three? What am I trying to do? You've got property. What are we getting at?
Stealing.
Admit that you knew he was living in the trailer.
Adverse possession.
Adverse possession. How many adverse possession cases have I litigated? Really none. I'm not sure that happens, but maybe it does. Okay. Took no steps to evict. Admit that at no time did you any attempt to conceal from you the fact that he occupied the trailer located at 16 Cherry Tree Lane. Perfectly factual questions, right? They're factual questions that, if you put them all together, come pretty close to proving adverse possession. A little more artful than just saying, did the plaintiff adversely possess your property? Okay. So technically, right, even though you will get every kind of question under the sun, especially in a jurisdiction like Kentucky, where people are just allowed to go nuts with requests for admission, technically, you can't ask purely legal questions, right? I think it's rare that you can come up with a purely legal question. The example that your book gives you is, admit that this patent is valid. That's one. So that's the whole point of the case, right? Admit that the element of malice aforethought is present in this case. You can object to that. You can object to that.
I think I'd also deny it.
Questions? Sample answers. Deny this part is really asking for a legal conclusion about intent, and you're going to have to prove that, plaintiff. But yes, I smashed the beer bottle over his head. Then it is not able to truthfully admit or deny the request, and this is where you have to be detailed, right? Why are you not able to truthfully admit or deny the request? Just saying, I'm not able to right now, I don't feel like it, that's not enough. You have to say why. Give them details as to why. And then the thing that tracks the language of the rule. Not able to truthfully admit or deny because I don't know. I've made a reasonable inquiry, but whatever I can get still doesn't get me there. Okay? This tracks the language of the rule. Unassailable. Got those? Questions about that? No? Good there. So the Azia, this case that you're supposed to read. How does it get to the Court of Appeals in the first place? Walk me through how we got there. It's a really important thing to take stock of, especially in a procedure class, when you read these cases. You know how and why a case got there. You're starting to think like a lawyer. What happened? Summary judgment? Motion to dismiss? Something else?
They didn't answer the request for admission.
I know that. How did we get to the, well, go on. Do you have more to say?
No, I want to hear it from you.
No, I want to hear it from you guys. Diversity? That's how they filed the case in the first place. I'm talking about how did they get to the Court of Appeals? Diversity jurisdiction is the thing that just gets you into the federal court to begin with. Fine, they're already in federal court, they're litigating, yes, based on diversity jurisdiction, but then what did they have to appeal? What? Well, okay, how do they get a judgment? You can't appeal anything other than a judgment, as far as I know.
So what I was saying was they didn't admit, and so the court deemed them admitted, and so I guess that's where remember.
How about the very first sentence of the case? Jeff?
The Southern Pacific They appeal from the judgment entered in favor of ASEA and from the denial of the motion for a new trial.
They move for a new trial. Move for a new trial. There's a judgment entered against them. They move for a new trial, which might suggest to you that they had a trial to begin with, although your excerpt does not tell you that. But they went to trial on this case, apparently. And then what happened at trial? They're litigating over stuff. This appeal is all focused on stuff that happened before trial. At trial, that mattered though, right? So before trial, there's all these requests for admissions. The judge says, those are going to be admitted. By the way, who do you not want to be in this case? Or that defense counsel. Not a good day for that defense counsel. Says, all right, all this stuff is going to be deemed admitted. They go to trial. Then they don't get to litigate that stuff that was already admitted. Right? See how that works? Defendant doesn't get to say at trial, no, that stuff's not true. And so probably suffers an outcome, we don't know what it is, but probably suffers an outcome that they'd rather not have suffered at trial. Right? That's how we get here. Pay attention to the way in which the plaintiff does these discovery requests in this case. You see that? Look with me at the top of page 544. And it says, each of these requests for admissions was accompanied by an interrogatory which asked that if the railroad's response was anything other than an unqualified admission, they should state the facts, documents, and witnesses upon which the response was based. Put a big star by that paragraph in your book, okay? Because that is the thing that really happens in the wild. I tried to find an example of it. I couldn't come up with one, but I've seen it. And the point to take away from all that is that you don't have to be boxed into within the confines of one discovery document that you tender to the other side. It doesn't have to be all requests for production of documents. It doesn't have to be all interrogatories. It doesn't have to be all requests for admissions. You can mix those together within the body of the document if it makes sense for you to do that. And that's what this plaintiff has done here. For every single one of those requests for admissions, they had an interrogatory that goes along with it. That says, all right, if you said anything other than admit, then tell us why and give us the complete basis for it. Smart practice? Pretty smart. Pretty smart. If you draft discovery requests for your firm over the summer and you do something like that, will you be the hero of your firm? Yes. Will they give you lots more work to do? You'll see. What was wrong with the defendant's answers? Answering party cannot admit or deny. See where I am? Right at the top of 544 again. Said party has made reasonable inquiry. Information known or readily obtainable to this date is not complete. Investigation continues. What's wrong with that answer? Yeah.
They found that it wasn't true.
Right. It wasn't true. Right. There's nothing wrong with the form of that answer. Okay? There's nothing wrong with the form of the answer. The answer tracks the rule okay. It's just that later discovery demonstrated that that answer was, in fact, not true. Okay? You have to make sure that when you're answering discovery, you put a reasonably true answer. What does the appellate court order in this case?
They remanded it to review the case for whether the district court was reasonable in not giving the defendant a chance to like amend his answers or anything.
Yeah. Yeah, go back and give us an opinion, right? Go back and give us some basis for the action that you took here. So it's kind of a soft reversal. We're saying, no, we're not going to say that you screwed this up, but go back, court, and tell us why you didn't screw it up. Everybody get that? That reading? Magic language here. This is the holding, right? If the information known or readily obtainable after reasonable inquiry was sufficient to enable the answering party to admit or deny, then a district court can deem those matters admitted. Tell me that in plain English. What does it mean?
If you lie about it, they're gonna say that you lied.
If, in fact, you had enough information to answer a request for admission, you just didn't want to, and you put that boilerplate language in your answer, even if it tracks the rule, that's not good enough. Okay? If you could have admitted or denied, and you said, we can't because we don't know, you're going to get stung. The way that the court stung this poor attorney here is by deeming all of those requests for admissions admitted. Okay. Everybody see what happened in that case? Understand the difference, the fundamental difference between this kind of discovery device and interrogatories and requests for production time. Yeah?
For the judge, whenever they go back and give an opinion as to why, they just talk about the two parties and their like over a year long discovery process and give that as a reason why it doesn't have to be more legal.
Yeah, I don't know. I mean, I think that the court will come up with something that's appropriate for the appellate court, right? But yeah, it seems like there's more than enough here to say this is why I reached this opinion, right? And especially since, I mean, it's kind of a curious opinion because it seems to me that there's enough on the record to demonstrate sort of persistent discovery violations, or at least discovery tomfoolery by the other side. But I think that the Court of Appeals wants the record to be cleaner on this particular issue. Just put that all down in an order, rather than just having it be part of the proceedings. If that makes sense. All right. So, let's see if you can do it. I want to see your interrogatory responses from last time. I have been getting emails of some of those, and we need to talk about those. So, let me see those, but also this is quick. You can do this real quick, right? Stay in your same groups in the last class. Assume that we're still in the battery case. Assume we're still in federal court, but it doesn't really matter. Give me 5 requests for admission that if they were admitted by the other side, would cause you to win the case on liability. That makes sense? Easy, right? Sir?
Professor,
Yes.
when do we show you our last class, our